You've done the responsible thing. You paid an attorney, signed a revocable living trust or a solid will, and walked out believing your assets would pass exactly as you directed. For a surprising number of families, that document never controls the largest pieces of their estate. The money moves accordingly to paperwork most people fill out in 5 minutes at a bank or brokerage and never look at it again. That is the core problem this video addresses. Beneficiary designations and joint ownership can completely override the estate plan you spend time and money creating. The result is unequal distributions, unexpected taxes, family conflict, and assets landing in the wrong hands. These are not rare edge cases. They are routine preventable failures. I'm John Conrad, forensic accountant and founder of Numeratus.us, the white glove concierge accounting firm for ambitious high net worth individuals, entrepreneurs, and startups. Retirement accounts, IRAs, 401ks, and 403bs, and many annuities pass by contract, not by will or trust. The financial institution pays whoever is named on the beneficiary form. Your trust language, your will language, even a handwritten letter expressing different wishes has no legal force against that form. A parent names the oldest child as primary beneficiary on a substantial IRA, intending that child to do the right thing and share with siblings. When the parent dies, the entire account belongs solely to the named child. Any later transfer to brothers or sisters is a taxable gift. Under current gift tax laws, amounts above the annual exclusion require a gift tax return and reduce the lifetime exemption. In addition, under the Secure Act's 10-year rule, most non-spouse beneficiaries must empty the inherited IRA within 10 years. The named child bears the income tax liability on those distributions, even if the money is later shared. The siblings receive after-tax dollars, while the tax bill stays with the original beneficiary. The estate plans carefully drafted equal shares, never operated. Contingent beneficiaries are equally critical. If the primary beneficiary predeceases the account owner and no contingent is named, the account may default to the estate and become a probate asset, exactly what many people sought to avoid. Regular review is not optional. Life events change the correct designation. The second major bypass occurs when an adult child is added to a bank account, brokerage account, or real estate deed, just so they can help with the bills. In most states, this creates a joint tenancy with right of survivorship. The moment the original owner dies, the surviving joint tenant becomes the sole owner by operation of law. The will or trust is irrelevant. This arrangement creates risk while the original owner is still alive. The joint owner can withdraw funds, and the account becomes exposed to the joint owner's creditors, divorce proceedings, or lawsuits. At death, the asset passes outside the estate plan, often defeating equal distribution among children or specific bequest to charity or a second spouse. Real estate is especially unforgiving. Adding a child's name to a deed is a completed gift for tax purposes and permanently alters title. Undoing it later requires the child's cooperation and may trigger gift tax or capital gain consequences. Families frequently discover the problem only after the parent has died and the land or home belongs entirely to one child. These transfers interact with other rules in ways that magnify harm. Income tax timing. Inherited traditional IRAs carry ordinary income tax. A single named beneficiary may face compressed tax brackets if the 10-year distribution period coincides with peak earning years. Spreading the tax burden across multiple beneficiaries through coordinated designations can reduce the overall family tax cost, something an uncoordinated form cannot achieve. Be a step-up in basis. Assets that pass through an estate or certain trusts generally receive a step-up in basis at death, eliminating capital gains tax on pre-death depreciation. Jointly held assets may receive only a partial step-up, depending on contribution history and state law. The difference can be substantial on long-held real estate or concentrated stock positions. Then we get to our favorite, creditor and divorce exposure. Assets held in joint tenancy or paid directly to an individual beneficiary become that person's property. If the recipient later divorces or faces judgment creditors, the inherited funds are reachable. Proper trust planning can provide far greater protection. What about blended families and special needs situations? Naming a child from a prior marriage as a beneficiary or adding a current spouse as joint tenant can unintentionally disinherit later children or destroy eligibility for means-tested benefits. These outcomes are permanent once the transfer occurs. What about Medicaid and long-term care planning? Joint ownership can be treated as a completed transfer that triggers look-back penalties, while properly structured trusts may preserve eligibility. Convenience joint accounts often undermine years of careful Medicaid planning. None of these consequences appear on the signature line of the beneficiary form or the joint account application. They surface only after death, when correction is impossible. And how do these mistakes happen so easily? Financial institutions present beneficiary forms and joint ownership options as routine administrative steps. The language is brief, the process is fast, and the long-term legal effect is rarely explained. People add a child's name for check-ready convenience or name a single beneficiary because the form requires one name. They assume the will or trust will somehow override the form. It does not. The same pattern appears with payable on death and transfer on death designations on tax and brokerage accounts and with life insurance beneficiary forms. Each of these is a non-probate transfer that operates independently of the estate plan. When the bulk of a person's wealth sits in a retirement account and jointly titled assets, the formal estate documents control almost nothing. So what are some practical steps that keep the estate plan in control? Coordination, not mere documents, is the solution. First, inventory every asset that passes by beneficiary designation or joint ownership. List the current primary and contingent beneficiaries and the exact form of title. Compare that list against the distribution scheme in the will or the trust. Any mismatch is a live problem. Second, prefer durable powers of attorney and properly funded trusts over joint ownership and day-to-day assistance. A power of attorney allows a trusted person to manage accounts without transferring ownership. Assets titled in the name of a revocable living trust remain under the control of the trust terms at death. Third, when beneficiary designations are necessary, as they are for most retirement accounts, name the individuals or the trust exactly as the estate plan contemplates. If a trust is named, confirm it qualifies as a see-through trust under current IRS rules so that the 10-year distribution period still applies correctly. Update designations after every major life event: marriage, divorce, birth, death, or significant change in asset values. Fourth, review the entire plan with counsel or your trusted advisors who understand both the documents and the non-probate transfers. Many estate planners now request a complete asset and beneficiary inventory before finalizing documents precisely to avoid these disconnects. Finally, treat the review as recurring, not one time. Beneficiary forms and account titles drift. Annual or biannual checks catch the drift before it becomes irreversible. What's the cost of leaving these gaps unaddressed? Families who discover these problems after death face limited options. The named beneficiary owns the asset. Courts rarely rewrite valid beneficiary designations or joint tenancy titles simply because the result conflicts with a will. Litigation among siblings is expensive, public, and corrosive. The tax costs? Gift tax on forced equalization, compressed income tax brackets on inherited IRAs. They're permanent. The people who avoid these outcomes treat beneficiary designations and account titling as integral parts of their estate plan, not administrative afterthoughts. They keep the legal documents and the financial paperwork in alignment. That alignment is what delivers the distribution the client intended. If your own beneficiary form or joint accounts have not been reviewed against your will or trust in the last 2 years, the gap already exists. Closing it is straightforward while you are alive and far more difficult or impossible afterwards. Estate coordination is not a one-time document exercise. It requires ongoing alignment between legal instruments and the financial accounts that move your assets. You want a clear inventory of your non-probate transfers, a comparison against your existing plan, and practical sequence for closing any gaps. Reach out to us at numeratus.us and book a call under privacy in our services page. The link is in the description. We approach these reviews with the same way we handle cost basis tracking, entity-level reporting, and audit-ready documentation, with precision, defensibility, and a focus on preserving optionality for the long term. Start with the review while the decisions remain fully under your control.